Does the order in which terms of a contract appear in that contract have any legal significance? If something appears at the beginning, is it given more weight? If it appears at the end, is it given less weight? We're going to find out all about the history of contract interpretation in this video. Stick around. Hey out there, welcome back to Wedding Industry Law. My name is Rob. I am an attorney representing wedding industry professionals. And if you have stumbled upon this video, then you are in fact watching the least popular YouTube channel dedicated to wedding industry professionals trying to keep it legal. And we have a real barn burner. We have a real exciting video for you. This week, we're going to be talking about whether or not where an item or a term appears in a contract has any bearing on any type of legal implication. Does it make it more or less enforceable, for example? But before we do that, really quickly, call to action. Please, 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 let's take this from the least popular YouTube channel to a moderately or a scintilla of popularity YouTube channel. And you can do that by subscribing or liking or providing a comment. I would greatly appreciate it. So let's get into the issue at hand, and that is we all have pretty similar contracts, not necessarily the same contracts, but they usually have the same flow. And does that matter? Does it matter that the top of the contract is the title, and then you've got, a paragraph that says whereas this, recitals, these type of thing? Why is that? Does that matter? And in today's day and age, I'll make this super quick. In today's day and age, typically it's not going to matter. And I'm going to tell you why. So when there is some type of dispute as to the scope or the interpretation or the meaning of a particular term in a contract, and that contract's in the hands of the judge, in almost all circumstances, the judge is going to be limited in terms of where they're going to get the information to fill those gaps, to be informed about what the contract means, to the actual document itself. So in other words, if there's a dispute about what the word taco means in a contract, the judge first, as an operation of law, has to figure out whether or not taco is itself defined in the contract itself. He or she, as the judge, cannot go and get testimony from the parties to the contract or go to whatever industry standards are. Like he or she can't go to Taco Bell and be like, hey, what does it mean to actually have a taco versus a gordita or a quesadilla even? The judge is limited to the contract. So it's called looking at the four corners of the contract. So any interpretation, any understanding is going to come from reading the whole thing like a book. So to the extent that the judge is able to come to an understanding as to what something means in that book, he's going to close it up and go, okay, I rule in a certain way, case closed. So as you can imagine, over time, the people drafting these contracts wanted to tell the story of where the parties are coming from and what they're actually wanting to do and be obligated to do in the actual document itself, like a story. So this is kind of why you get a lot of, at least in the old contracts, you get a lot of formulaic language at the beginning, because it's kind of like the opening chapters, and these are called recitals. And it's like, whereas DJ Taco desireth to play music and records for money and compensation, and Madam Burger desireth to have DJ Taco, blah, blah, blah. Whereas now, therefore, that is designed to, at the beginning, give the judge who's reading it an understanding as, okay, who these people are. Like, why does this document even exist? Okay, it's DJ Taco and Madam Burger gonna do a wedding, gonna DJ the wedding. Okay, I get it. Now that's the opening salvo of the story. Now this level of needing to tell the story, in my opinion, has gotten less and less and less necessary the more specialized contracts have become. So that way, the opening title of it saying DJ contract is replaces that, 7 or 8 paragraphs of whereas, now, therefore. And the judge reading that and go, okay, it's a DJ contract. I get it. Maybe 200 years ago, there weren't that many DJ contracts. So we're seeing now it's less and less necessary to tell that story, and the judge reading it is not going to be confused about why the parties are there. Then you get headers like, this is the part about non-refundable deposits. This is the part about limited liability, that kind of thing. Context that is so that information contained in there is easy to find. So I guess at the end of the day, as you're telling the story in your contract, it's not necessary to put one before the other. The reason why you would want to put more critical terms at the beginning is just as a solid to the judge and even the clients, where, people want to know how much they're paying. Maybe that's in the front. People want to know what the policy is or the terms are with regard to non-refundability. That's probably going to go in the front because that's the most important part. And you don't want to have to go searching through pages and pages of stuff to find the information that you want. So, but just because maybe your non-refundable language that you use is the last thing in the contract doesn't mean that it's any more or less enforceable. It's just that the person that wants to know what that is going to have to search for it a little bit harder. So at the end of the day, that's really it. Like you want to put information in the contract that's going to inform a future trier of fact or the judge to understand what's going on and why it's going on as succinctly as possible, because that's typically they're only going to be looking at that document. And so there's nothing that I've ever seen in the law that says just because something appears at the end doesn't mean that it's any less important than if it appeared at the beginning. And in fact, even though it's not exactly necessary, sometimes you'll see in contracts and it'll say something along the lines of, just because something appears in one header doesn't mean that it doesn't apply to the rest of the contract. But that's something that's so, like, we're not talking about 60-page, mergers and acquisitions agreement. We're not talking about Apple buying Meta or something like that. So in terms of your typical wedding business contract, I wouldn't sweat too much about it. The reason why the more important things are in the front and the more boilerplate things are at the back typically is just about their importance, and people want to get to the important things first. So I hope you found this video informative. You've learned that, the judge has to look at the contract itself most of the time. So you need to make sure that your language is succinct and tells the story. And also that it probably is not going to matter too much where a certain term appears in the contract. So bottom line, if you did find that interesting and you didn't fall asleep or click off to something else, then please be sure to like and subscribe. New videos just like this one, probably better than this one, come out every Monday. And with that, folks, we'll see you next time.